Welcome to today's webinar. My name is Rafael Aquino. I have the pleasure of here being with Stephen Rappaport. We're going to give our audience about a minute or two to be able to log in, and we'll get started just shy of about 11:01, 11:02 with today's webinar. It's going to be an excellent topic where we're talking about covenant enforcement. I'm sure the HOAs and condos that are here with us today are going to have questions. So if any questions do arise, please feel free to click on the Q&A, type in your questions. Stephen and myself will do our best to try to get through all the questions. If we don't, we will provide our contact information at the end of the presentation, or I should say the webinar. And you could send it to us and we'll do our best if possible to be able to answer that, assuming obviously we're not answering any legal questions or any representation. So again, for those of you that are logging in, my name is Rafael Aquino. I have here Stephen Rappaport with Sachs. We're going to get the webinar started in about a minute or so. And the webinar today is going to be discussing about covenant enforcement. So we'll give it just 1 minute, we'll get started. All right, great. So the logins look like they're steady. So welcome to today's webinar. My name is Rafael Aquino. I am with Affinity Management Services. In today's webinar, we'll be going over covenant enforcement. I have the great pleasure of being here and sitting alongside, or I should say virtually, alongside Stephen Rappaport with Sachs and Kaplan. Welcome to the show. Welcome to today's webinar, Stephen.
Thank you. Good to be here.
So a little bit about Stephen. Stephen is a partner in the Community Association Practice Group. He handles transaction matters for the firm, community association clients, including drafting amendments to governing documents, attending board meetings and elections, handling covenant enforcement disputes, and providing opinions on all aspects of association issues. So again, welcome today, Stephen, for being on the webinar with us today.
Thanks.
As for myself, my name is Rafael Aquino. I'm the CEO and co-founder of Affinity Management Services. We are a community association management company. Our core focus is to manage condo associations, homeowner associations throughout Miami-Dade, Broward, and Palm Beach County. As always, I want to thank all the board members that are here today. I know that you're not paid for what you do, and it says a lot about you in putting in the effort to gain additional education in order to make sure that you're managing your communities in the proper way. For those community association managers here today, I also want to applaud you for taking the time to gain some additional knowledge and also improving our industry as a whole by knowing what steps you to take in order to enforce covenants or what the process is like. So with that said, why don't we get started, Stephen? So, as from a management perspective, we get asked a lot, especially with the newer board members. They don't have a good understanding of the documents. They'll talk about bylaws, they'll talk about articles of incorporation, and they kind of don't understand how it all comes together. So, if you can kind of give our audience today a little bit of an understanding of what is like a declaration and kind of, how the covenants impact the decisions and the responsibilities that board members and managers alike have.
Yeah, happy to. And I think that's a perfect place to start. In fact, that's how I start all my board certification classes, by giving an overview of your documents, because it is very sometimes confusing when you're having so many sets of documents that say so many different things. But I think the two key points I want to make are the hierarchy of your documents and what your documents actually are. And most associations, probably 99% of you, will have four actual sets of documents. You'll have your declaration, and if you're a condominium, it's a declaration of condominium. If you're an HOA, it's probably a declaration of covenants, declaration of restrictions, something along those lines. But that's your top document. That's the covenant that binds the land and the use of the property. So that's where you're going to have your rental restrictions, your authority to collect assessments and to lien for assessments. All your important substantive rights and remedies are really contained in your declaration. Your second document in the hierarchy is your articles of incorporation. That is really just the corporate charter that makes you a corporation with the state of Florida. It can be 1 page, it can be 10 pages, but that's what makes you a corporate entity and gets filed with the state. The rest of your documents really get recorded in the public records of the county, but your articles is with your state. Your bylaws, what a lot of people like to call their whole set of documents the bylaws, but your bylaws are actually just one subset of your documents. And that's sort of an expansion of the corporate powers from your articles of incorporation. So your bylaws may talk about the number of directors you have, whether you have staggered terms, if there are standing committees, notice requirements for board and membership meetings, and so forth. And then finally, you have your rules and regulations. And that kind of leads into the second important point that I want to hit, because a lot of people want to make rules and regulations and enforce them. And it's important to keep in mind the interplay between your declaration on the one hand, which is your most important document and can be, and because it's the most important document, usually requires a supermajority of members to amend, and your rules on the lower threshold, which only usually require a board vote. But a lot of associations want to throw as much as they can in the rules. And it's very important to point out that your most important substantive leasing restrictions, or not just leasing restrictions, but your most important use restrictions really should be in your declaration, unless you have a good rulemaking authority, or unless there's something in your declaration that delegates that issue to the rules or to the board. And we can kind of talk more about it, and I'm sure there's going to be questions about that. But the two main reasons for that is because, number one, rules can't conflict with a higher document, and chances are 9 out of 10 times, if you're trying to do something by rule, there's probably something in your declaration that deals with that issue. So for example, let's say you want to do a rule that says you can't lease for less than 6 months. So you want to throw that in the rules because the board can adopt rules and you don't want to have to go to a 2/3 vote of the membership. Well, your declaration may address that very issue, in which case there's going to be a clear conflict. But I would tell you that even if that issue is not addressed in your declaration at all, and you have something in your declaration that talks about tenants or talks about leasing without putting on restrictions, that to me is an inherent conflict, because that's saying the declaration is allowing for leasing with no restrictions. I think it would be very difficult to put a very substantive leasing restriction into your rules when your declaration gives you some very broad authority. So that's just one of many examples that we can talk about. But this is a course on covenant enforcement. I think it's very important. I think the most important question that we have to start with is, what are we trying to enforce, and where is it in our documents? That
Right.
has to be your absolute starting point.
Correct. Excellent point. We find it from a manager perspective where boards kind of want to take the easy way out and add it to the rules. And we find that overall, it's not really the best step. The idea is to be able to put whatever changes are going to be made into the declaration, because do keep in mind that if you put it into the rules, the next board of directors can easily change that out as well. So that it is better to go through the right process and amending the documents and doing it the right way. So Stephen, with regards to the declaration itself, who is entitled to enforce the declaration?
That's a great question. And normally people just assume that the association has to enforce everything in the declaration, and that only the association has the rights of enforcement. And actually, if you look at both 720 and 718 for HOA, remember 720 governing HOAs and 718 governing condominium associations, they both say that the members of the association have their own independent right to enforce the documents. It's very rare that it happens, very rare for an owner to want to have to go through that process. But especially if you're dealing with an issue of a nuisance or a neighbor-to-neighbor dispute, those individual owners, if they have an issue with their neighbors, they have a right to hire their own counsel and seek injunctive action or some sort of remedy through the courts on their own against a fellow member. They certainly have the right to take action against an association as well. But you have independent authority as a member of the association, and you also have the same prevailing party attorney fee provision. So if you sue one of your neighbors for a nuisance or because of a violation and you win, you may be entitled to an award of your attorney's fees as well. So most people don't realize that the members of the association have an independent remedy that's pretty much almost equal to that of the associations.
Excellent. And when it comes to the covenants, are covenants required to be enforced? So for instance, many times, certain properties we're managing, it depends. The board will say, look, we just want to focus management on enforcing roofs that are dirty or driveways that have oil stains. What's your position on the enforcement of the covenants themselves?
So it's a really great question. And I guess the lawyerly answer is, while you may have an obligation to enforce, you don't necessarily have an obligation to take every single action all the way to a lawsuit. But really what you should do is look at the documents. And a lot of times, we get accused sometimes as lawyers of being wishy-washy sometimes on difficult issues. And we always say, well, I'll give you some general thoughts, but you really got to look to your documents. But it really is so true. And the reason I say that in this instance is because there's actually a specific case that addressed the enforceability of covenants issue. And in the case that held that the association was not obligated to move forward with an enforcement action for a particular violation was because the document enforcement provision in the declaration said that the association may enforce the declaration through various means. And we'll talk about that later, your different remedies in terms of fining and court action and mediation and so forth. But look to your enforcement provision in your declaration. If it's got some very broad language, such as the association may have the authority to enforce or may enforce by the following means or so forth, that use of the word may gives some flexibility to the board. And what I mean by that is, remember, as a board, as board members, you are subject to the business judgment rule. And what the business judgment rule in Florida says is board members are obligated to exercise reasonable and prudent business judgment in reliance on their experts in making their decisions. So if you have a situation where you have maybe 100 different violations in your community, but maybe you're a small community with limited resources, or maybe we're in the middle of a pandemic and it's not the right time to enforce and be nitpicky over certain things, or maybe we're in a situation where we're low on cash for whatever reason, we just went through a hurricane and we have maintenance issues that we need to address and we can't spend the money on enforcement right now. You have the right as a board to make business decisions to say, hey, you know what, we'll send a violation letter for this violation, but we don't have the resources right now to go to mediation or to go to the lawyer and start an injunction action. And as long as your documents don't have very strong binding language saying that you're obligated to take every single violation all the way through to the final remedy, then you're going to be able to make those flexible decisions. Now, and we'll talk about this when we get into different defenses like selective enforcement, that could open up a Pandora's box of, well, if we're deciding not to enforce this particular violation, how do we enforce others? And we'll talk about that a little bit later in the session. But the bottom line is there is some wiggle room. There is some flexibility for a board to say, hey, you know, we just don't think that that's important enough of an issue right now for us to start calling the lawyers and dealing with stuff. Send him a violation letter, let him know he's in violation, but we'll leave it at that for the time being until we have more resources. And that's perfectly viable strategy for your board.
Correct. And I would agree with you completely there, Stephen, because what we have found is it's worse to not do anything and then later want to start taking steps. So we have, for instance, certain associations where they have a challenge being able to get a committee together. Yeah. Our recommendation is, listen, that doesn't mean that we shouldn't send, the violations, as you stated. What we should do is at least put that person on notice. And then when you're able to put that committee together, then at least, you could say you've taken X amount of steps. And at this point, then we're going to take whatever action or whatever steps the board decides at that moment. But that's an excellent point. I believe that it's important to at least adhere to it, because as a board, it's your fiduciary duty to really follow to the letter of the word of those documents. And as you stated earlier, boards do get concerned of contacting the attorney because of cost. But ultimately, what I like to advise boards is you're managing a business. While it's a nonprofit, it doesn't have excess cash flow. You are managing a business. So part of managing a business means having the right partners with you. A lot of times those responsibilities want to be pushed onto management. And, we do our best, but ultimately we're not permitted to interpret the law of statute or even what's in the document. So we rely heavily on partners such as yourself to be able to guide us through these, so that the decisions that are made using that business judgment rule. We could say we reached out to Stephen, he gave us an opinion on this, and this is the direction that the board decided to take. That presented in a court is going to hold much more stronger than, our manager reviewed the documents and told us we could do X, Y, Z.
Yeah, so, absolutely. And let me just piggyback on that for a second, because when I say that, boards are entitled to make a decision that they don't necessarily want to spend a ton of attorney's fees on an issue, that doesn't necessarily mean don't contact the lawyer.
Correct.
It might just mean we don't want to file a lawsuit right now or do a lot of extensive legal work on it. But you really should be encouraged, though, if you're dealing with a complex legal issue, to rely on your experts. And the main reason is not so that we get to bill our time and talk to you, but the main reason is because part of the business judgment rule is it's a protection for board members. And what it says is if you're relying on the advice of your experts, you're going to be better protected. So it's important to get that whether it's a formal opinion letter or an email from counsel or an engineer report, if we're talking about a defect for something, or an accounting report or whatever it is, rely on your experts and reach out and talk to them. Better to have that phone call, incur the small charge for it on the front end to deal with the issue, than not make the call and wind up in a $10,000 or $50,000 lawsuit or more that could have been avoided with a 5 or 10 minute conversation. So
Correct. Very great point. And as a tip as well to the board members where they're hesitant, for those that are maybe have a little bit tighter budgets, remember that when you contact your attorney, if you're self-managed, your manager, or if you're professionally managed, you should be saving those opinions. So at least you can reference them. It doesn't mean that one opinion will be used for every other decision that you make. But if you have a strong management partner or a strong manager, you're saving these opinions, and that way you can reference them in the future, and then you can work with your attorney if you just need to fine tune something because there's slightly of a different interaction or action that needs to be taken. So let's switch gears here, Stephen. Let's go into a little bit with regards to enforcement, which I'm sure what a lot of our listeners or viewers are here for today.
Yeah.
Can you talk to me a little bit about what you recommend your clients when it comes to the enforcement of these covenants, and what are the steps that should be taken?
Okay. Well, and I like your perspective from certainly after I get finished on the management side of how you recommend doing things from, because before it gets to the attorney, there's usually a process that management goes through in terms of, courtesy violations and, how many letters we want to send. But look, I mean, enforcement I am always of the school of opinion that the less formal we have to get, the less we can involve the attorney, and the more we can try to work it out with the owner directly, and then then get the attorney involved if it just doesn't work out. I am a resolution-oriented attorney. I tend to try to favor, let's talk it out with the owner, send a friendly reminder first, try to get things worked out, settled, whatever it is, without starting World War III in your community or incurring a huge bill with the attorney, at least on the front end. Now, if that doesn't resolve things, I mean, certainly I've dealt with the unreasonable owner or the resident dissident that just digs in and decides, what, I don't care what you say, I'm not going to do this, I'm not going to clean this, or I think it's already clean, or I'm not going to move this vehicle, or whatever the issue is. Then you need to look at what your different remedies are. And remember, enforcement of your documents, you have many different remedies. There's not just one exclusive remedy. So you have the authority to send demand letters. You also have the authority, if you have the proper committee, to levy fines. So let's talk about that for a second. In both HOA and condos, you have a statutory right to levy fines for violations of the governing documents. You have to have an independent committee. You have to give a hearing on 14 days notice. The board imposes the proposed fine and then sends it to that committee with that 14-day notice and the hearing to either approve or reject the fine. But you have that right to levy a fine, and hopefully that would remedy the situation. Now, what if they don't pay the fine? Or conversely, what if they pay the fine and say, okay, that's fine. It would cost me $10,000 to fix this violation, but I'll pay you the $1,000 fine that you just sent me. That's not the end of the story. Just because the fining situation doesn't work out, doesn't mean you don't still have that underlying authority to move forward with legal action. And what that means is different for HOAs and condos, but basically ultimately going into either court or arbitration for a condominium. So if the fining process doesn't resolve things, if the discussion process doesn't resolve things, if the letters back and forth don't resolve things, then you as a condominium association can then go through arbitration with the the Department of Business and Professional Regulations. There's an arbitration section, and 90% of covenant enforcement disputes have to go through arbitration first. And then if it doesn't resolve in arbitration, then you can go through what's called a trial de novo and go into court and try to get the remedy if it doesn't work out in arbitration. And for an HOA, there's no arbitration for HOAs. HOAs have to go through mediation first. You have to offer a pre-suit mediation, give the person 20 days to respond, go through a mediation session, hopefully get resolved in mediation. If it doesn't resolve in mediation, or if they don't respond and they ignore it, then you can also independently go to court to try to enforce the document. So there's many different levels, and depending on the complexity of the issue and the personalities, most often the personalities involved, will depend on how far along the process you have to wind up going. But the key important thing there is each of these are independent remedies that you have. It's not I have to choose one or the other, or if the fine situation doesn't work out. Let's say you find somebody that $100 a day up to $1,000 for a violation, and the fining committee rejects the fine. They just say, you know what, we don't think there's enough evidence here, or maybe we like the person and we don't think they should have to pay the fine. That doesn't mean you still can't turn around and go to either arbitration as a condo or offer mediation as an HOA. The fact that the finding committee turns down the fine does not mean that they're saying there's no violation. It just means that they're rejecting, for whatever reason, the levying of the fine. That underlying violation still exists, and your board, as part of their duties, has a right to continue to prosecute that violation.
Interesting. I've never, I haven't heard that. That's an excellent point, Stephen. Wow. Wow. Interesting. Yeah, because most of the times it is believed that once you can't find, you don't, if the committee decides not to apply a fine, that, okay, well, then the violation doesn't exist, but you're completely right. The violation still does exist. It's just not placing that monetary value or that cost towards it. So I'll give our listeners and viewers a little bit of a breakdown of how, from a management perspective, we would handle the course of enforcement. So, and I'm going to start even earlier on, because I believe that it's very important. I'm sure, Stephen, you would agree that prior even to sending any of these violations, you want to make sure that whatever system you use, whether it's an old, taking pictures and not using any technology nowadays, but you want to make sure that you're at least entering into whatever system you use is your actual covenants and restrictions. You want to make sure that you're at least noting, okay, this is part of this section. You're not interpreting the law. If you're a manager, what we're doing is we're copying and pasting the specific violations. So if it states that you need to have a particular kind of window, then that's what we want to be able to place there. If it says garbage cans are not permitted on the street on these particular days, then that's the language you want to be able to place there. Once you have that set up, then really it all depends on the committee and the board of directors of how many notices they're going to want to send, or even you have to check some documents, because some documents will outline what are the specific steps that must be followed before you can before you can fine anyone. In most cases, I'm going to speak in general here, you're going to want to send either a first, let's say a friendly reminder, or a first letter advising the individual of what the particular violation is. Every violation will possibly have a different time period in order to cure. If you have a garbage can violation, you're going to expect that person to cure it that day or the next business day. You're not going to expect the same thing if someone has their home that needs to be painted or a roof that needs to be pressure washed. You want to be able to give them some kind of time. And I would say, in our case, what we see is anywhere between 30 to 45 days for those kinds of violation. If that hasn't occurred, then if the individual hasn't corrected the violation that you had sent, then in a normal basis, you would then send a second letter. And this we would call similar to, let's say, a collection letter, a final letter. That final letter will outline, okay, we're going to give you X amount of dates, or you shorten the time frame. You have 10 more days to get this fixed. If it doesn't get fixed, we're going to move it forward into either committee or to the board in order to request a fine. And then typically after that, they're normally moved directly into a hearing. And the hearing, as Stephen mentioned earlier, you do need to provide 14-day notice to that individual. As a board or as a manager, you're going to need to put on the agenda what the individuals that are going to be attending that hearing. Normally we put the address, we don't put names. And then they'll come to that hearing. And depending on the structure, normally a board has to say, we want this to move forward. And then the committee will decide whether to fine that individual or not. That's kind of the process in a very high level. Overall, some boards are very aggressive. They just want to fine. I'm not a big believer in that fines really resolve the issue. I believe that you need to have a very consistent process in your setting up your meetings. So for HOAs or condos, maybe set up your hearings once a month, so that way your manager doesn't have to be asking the committee or coordinating. Let's say every third Wednesday of the month, we host our committee meeting to have the residents come in. And that way your manager can coordinate the necessary timeframes, get the notices out when they need to be out. And at that meeting, you can determine the next steps. If you have a good technology product, which there are great systems that are out there for managing your covenants and conditions or your violations, as a manager, you don't even have to print these notices of what you've sent. You can pop up a laptop and you'll be able to see when the first notice was sent with pictures and timestamp of when the manager sent it or the committee member, whoever it may be. And that way the process moves much, much quicker. So technology has definitely helped us nowadays. But more important than anything is, if you have that consistent process in place, you'll notice that more residents are going to comply with what your covenants and conditions are. If you're very inconsistent in your process, then that's where you're going to find where you're going to have more challenges in getting these violations corrected. So Stephen, let's say we go through that entire process, right? The management company or a self-managed community does what they need to do. They send all the necessary letters. What remedy do they have if they decide, listen, we find this person, they haven't paid the fine? What remedy do they have, let's say, with counsel to take this to the next level to make sure that it gets corrected?
Okay. So, and I'm going to address that briefly, and then I want to backtrack a little bit more on the procedure of
Sure,
fines, because I do want to make a couple distinctions between condos and HOAs that I think are very important.
sure.
And then I also see a question and a couple of questions that I want to hit on in the Q&A as well that kind of dovetail into this also. But look, if the fine is approved and they don't pay and the violation still exists, then at that point, if you're a condominium and you want to move forward aggressively, then the next step is filing an action for arbitration. You can try to collect the fine in small claims court. I don't believe that a damages action is the subject for an arbitration, so I don't think you can go through arbitration to collect the underlying fine. So for a condo, you're a little more limited procedurally in terms of how to move forward. I think you probably would have to either try to get that fine approved in small claims court, which may or may not be worth the effort. You probably just at that point want to move forward with the arbitration to try to correct the underlying violation. For an HOA though, and this is why I want to talk a little bit more about fining, because there is a little more teeth to fining in an HOA. So the answer for an HOA would be the same, other than that you would just move forward with your mediation and then ultimately a lawsuit if it didn't resolve in mediation. But fining in an HOA is a little bit different because condo law restricts what you can do with fining. It says you can fine for up to $100 per violation, up to $1,000 maximum for a continuing violation. So $100 a day for 10 days for a continuing violation. And it specifically says a fine cannot constitute a lien on the unit. So you can't lien for the non-payment of the fine. So you're very limited as a condo association in dealing with fines, which is why fining is probably not as great a remedy in condos as the arbitration process really is. But for an HOA, what 720 says is if the governing documents provide, you can actually go above the $100 per violation and $1,000 in the aggregate if you amend your documents, or if your documents already provide for those higher amounts. And what it also provides is that if the fine is $1,000 or more, you may, depending on the language in your documents, be able to lien for it. So what it says is a fine of less than $1,000 may not constitute a lien, which implies that a fine of $1,000 or more may constitute a lien. I still believe you have to have that language in your declaration to create that lien right. But there's a lot more teeth to fining if you line up your ducks in the right way and maybe amend your documents to give you that ultimate authority of increasing the amount of money that you can charge somebody for violations and create some lien rights to the process as well. If you can get that through, whether it's a 2/3 vote or 75%, or maybe hopefully a majority, some declarations only require majority, you can do that and set yourself up. You're going to have a lot easier time maybe enforcing your documents as an HOA, because it's going to give your fining process a little more teeth. But again, ultimately, if that doesn't resolve the issue, then whether it's arbitration for condo or mediation for HOA, that's going to be your next step. The other thing I want to talk about, there's a couple questions here in the side. One asking about where this gets back to the hierarchy of documents. Where does the replat agreement range? I'm not sure what replat agreement you might be talking about. I probably have to see the exact language. If you're talking about a replat declaration, then that's just going to be in the same hierarchy of the declaration. Usually a replat declaration will be a declaration for a sub-association of a master association. If it's just a simple agreement between homeowners, then it might just be enforceable as to those homeowners. So again, I probably need a little more info to give a better answer on that question. But there is a question about towing, and that's a good question in terms of enforcement, because for certain vehicle restrictions, in addition to fining, in addition to arbitration or lawsuits, if the parking is in the common areas or common elements for a condominium, you may have some authority to tow or immobilize those violating vehicles. So let's say you have a commercial vehicle violation in your documents, or a restriction on trucks of a certain height or whatever it is that can't be parked on the property, and someone's parking a violating vehicle in their common element parking space, or in a common element guest parking space, or on the streets, or the clubhouse parking lot, somewhere that's common areas that's not their individual driveway or property. The Palm Beach, at least for sure in Palm Beach County, I think most counties have this, but certainly state law allows for associations to tow or immobilize violating vehicles from association property.
Correct.
If you give proper notice of the tow, and if you have the proper signage in the community for the towing. So you usually work with the tow company to get that signage, but that may be another remedy for certain vehicle violations where you don't have to go through court. You may not have to worry about fining. And that's another remedy.
I have another good question here, and it's basically from an anonymous person. It says, does a violation without a fine need to be issued at a meeting, or can it be issued without a meeting by the board?
A violation without a fine?
Yeah, it says a violation without a fine need to be issued at a meeting, or can it be issued without a meeting by the board?
I think ultimately you really should be making decisions at board meetings, but I think most associations operate under sort of general day-to-day functioning that if you see a violation, we can direct management to send a violation letter out. Usually that's part of management's contract. Usually
Correct.
there's something in the management company's contract that says that they're responsible for sending violation letters out when they see violations. So if you have that in your contract with management, then to me, that's a board delegation of that authority in the contract from the board to management to send those violation letters out. So I don't usually take a very hardline approach in terms of those things. I think, certainly filing a lawsuit or sending things to the committee, levying the fines, those things should be done, by board votes in meetings. But just your day-to-day sending of violation letters. I mean, if you're an 1,800 home community and you have 100 and something violations that occur on a daily basis, it's kind of hard to have to call a board meeting every time you want to send a letter out. So I think you have to also have some practicalities to this as well, and kind of delegate some authority to management to handle that aspect of the process.
Yeah, that's correct, Stephen. So I have a question here from Wes, which kind of addresses that with regards to the violation itself. And as you stated, Stephen, in most management contracts, it is going to be included that part of responsibility is going to be to manage the violations and take care of that process. A lot of it does depend on the size of your community, as Stephen gave an example of an 1,800 unit community. Communities normally of that size actually have what's called a violations coordinator on staff that assists, that their full responsibility is just sending violations and managing the violation process on behalf of your manager. For the more smaller communities, let's say in the 300 to 500 units, traditionally that is managed either by the assistant that has a CAM license or by the CAM, and we're addressing it. West asked a question if the president should be the one sending the letters. If you have a management organization, Wes, I strongly would recommend that your manager send that. Ultimately, you live in that community, so let us be kind of we play the good cop, bad cop situation there. We're enforcing the documents on your behalf. So I would recommend that you have your management team, as Stephen said, you delegate that work and we can address it. For the very large communities, we maybe have some communities that have 6,000 plus units on the call. It depends. I've seen it multiple ways where you'll have a committee that assist the certain violation coordinator, since then, we'll break it down into sections where this committee member lives in this part of the neighborhood. They'll report the violations to the coordinator, and the coordinator will then send out the violations. So, if you're working with a strong management partner, there's going to be a strategy to this process. You definitely don't want to just do things wild west, where all of a sudden you just go crazy and start sending violations. When we take on some new communities where maybe they haven't had the TLC that they should have had over the years, as an organization, we do get some pushback in this approach, but we kind of want to break it down. Last thing we want is to get into a community where violations haven't been addressed, and we're sending thousands of violations. The argument could be had, well, if you send it in pieces, people are going to get bothered. What we try to do is maybe try to break down and have a strategy for it. Are we going to focus on this sector first, and then we're going to do all the violations for this sector of that large community? Then we'll go into the next sector. And before that, you want to at least give the residents at least a warning. Hey, over these past couple of years, the previous board or previous management, whatever it may be professional about it. Wasn't enforcing the covenants, and we are going to enforce the covenants. These are the common issues that we see, and we're going to start enforcing within 30 days. That way, you're giving the residents, you're providing them a level of service, you're communicating with them and letting them know, listen, we're going to start enforcing. If you see these kinds of things in your home, make sure you're addressing it, because once we start going into the steps that we're going to take, we're going to follow the process that the documents state. And a last important tip, especially for the managers or committee members, is if someone does correct the violation, make sure you provide that little white glove service where you send a thank you. So you can add that in the stages or in the letters that you have. So if someone, decided to paint the home without paint the home that needed to be painted, then close out the violation with a thank you letter. Thank you for taking the time to paint your home. We greatly appreciate it. It helps us XYZ. So taking those small steps, help. in not just the way you're managing your association, but also in the culture of your community itself.
I see a couple questions, a couple parking specific questions, and then one question on the committee for, so I want to try to jump in and try to
Sure.
backtrack on those. The couple parking questions, one is that you want to set up alternate side of the street parking, what can we do? Again, as long as the declaration doesn't specify where cars have to be parked, that to me, and as long as the declaration gives you broad rulemaking authority, which most do for the, especially over common areas. So if we're talking about alternate side of the street parking, the streets are being common areas, I think you would have the ability to adopt a rule by board vote to have that alternate side of the street parking. And I know many communities do that. So it's a very common thing. I don't think you need an amendment to the declaration, again, unless it would somehow conflict with the declaration. The second parking question was, if the documents don't talk about pool parking, but the rules do, can we tow? Again, making sure that the declaration doesn't specifically address it at all, and the declaration gives you that broad rulemaking authority to adopt rules restricting parking in the pool areas or other common areas, then yes, if it's a legitimate rule, you have the right to enforce the rules, and part of those that enforcement would be towing, again, subject to notice and signage requirements. But yes, towing from a common area parking space of a violating vehicle is absolutely appropriate, whether it's a restriction in the declaration or a rule. The only thing is, getting back to the discussion about rules and versus declaration, is declaration provisions are presumed to be valid, whereas rules can be argued or can be challenged on a reasonableness standard. I don't necessarily see anything wrong with having rules like alternate side of the street parking, or having certain restrictions on pool parking and things like that. But again, remember, anytime you're trying to enforce a rule, you may be subject to a reasonableness challenge, whereas if you're seeking to enforce something in the declaration, the court is going to construe it to be deemed valid. So that's why it's also very important, if we can get something into the declaration, to try to get it into the declaration.
Good point. We have a question here, Stephen, from Francis, that wants to ask, which is a great question: what constitutes an independent committee for that enforcement?
Yeah, so what 720 and 718 say are the committee that levies that approves the fine. Remember, the board levies the fine on the front end. So the board makes the decision that we see a violation, we want to issue the $100 fine. If it's continuing, $100 a day up to the maximum. And then we're going to send it to the committee. We're going to give the 14 days notice. That committee that ultimately either approves or rejects the fine must be made up of at least 3 members of the community who are not officers, directors, or employees of the association, or a family relative of such person. So that's what I mean by independent. It's going to be no relation to the board members or officers or employees of the association. 3 completely independent members of the community that are basically going to sit as the jury, where the board has already issued the fine, and their sole job, and the statute was amended a few years ago to specifically put in language saying the sole job of the committee is to approve or reject the fine as levied by the board. So there's no ability for that committee to say, hey, we think there's a violation, but we think $100 is too much, we'll approve a $50 fine. The committee's not to go above, below, negotiate the violation. Their sole job is yay or nay on the proposed fine. Now, there are some communities, and I think, Raphael, you alluded to this, that have other committees that help in the enforcement process. That's perfectly fine. In fact, I have a client, and I think this may be a little overkill, but for a larger community, this may work, where they have a covenant enforcement committee on the front end that works with the board and management to investigate violations that have been alleged, and to make a recommendation to the board as to whether or not a fine should be issued. Then the board issues the fine and sends it to the grievance committee or the fining committee, which is then that independent committee on the back end to either approve or reject. So if you wanted to have a third layer in the process of having some other committee being involved in the investigation or being involved in the process, that's perfectly fine. And that committee is not governed by the statute. It can be made up of whoever the board wants to delegate that authority to. But that judge and jury at the end of the process that has the ultimate say on whether to approve or reject the fine is that independent committee.
So Jackie Grant here asked a great question having to do with the committee. Do you recommend it to be a standing committee or an appointed committee?
It probably doesn't matter either way, because it's a committee that's authorized by statute. So whether it has to be appointed anyway. I mean, the members at least have to be appointed anyway. So whether it's a standing committee referred to in your committee rules or in your bylaws or wherever, or whether it's just a committee that the board decides to appoint, I think as a practical matter, it's basically the same. It is a committee whose membership will have to be appointed by the board, and will report back to the board. So I don't know that it matters, but I don't think I have a recommendation either way.
Yeah, correct. Our experience has been that normally that committee will just sit there for as long as the current board is, unless a new board comes and decides to dismantle that committee and create a whole brand new committee. So I know what we have seen, and we've spoken a bit about fines. What's your opinion on the way fines should be applied? So I have some clients that have they've done the right step, in my opinion, where they'll say, okay, these kinds of violations will have these kind of fines. So as an example, garbage bins out $25 the first time, $50 the second time, and so forth. I have associations that just follow $100 per day, doesn't matter what the violation is. What do you see, Stephen, from your clients, or what's your take from, I guess, a legal perspective of what you would recommend to the board?
I tend to see, that's another one of those things where I don't necessarily have a recommendation because I think it works well either way. I
Yeah.
think I think for certain minor violations, it probably makes more sense, or in a situation where you may have first offense, somebody that's never done anything wrong before, maybe have a lower fine at the beginning. I think that's perfectly appropriate. One thing you can do is adopt what's called a fining schedule. Maybe you have
Mhm.
something where you say, these types of violations will get the $25 fine, these types 50, these types 100, or first time gets a certain amount and so forth. But adopt that fining schedule and maybe even publish it to the residents of the community so that they're aware of what the process is going to be. I think that's perfectly appropriate. But I find the smaller communities. I think when you come to smaller communities, I don't know if they want to get bogged down in the minutia of that as well.
Yeah.
So I tend to see that the smaller communities, or maybe even yeah, I would say smaller communities maybe just stick with the sort of $100 up to $1,000, and they just kind of leave it at that because it's just easier for them.
It's easier, correct.
Yeah.
My biggest concern when we take on a client is it's just I like to have some kind of order. An ideal circumstance, I would say it's simpler just to know $100 up to $1,000, because that way your letters are standardized as well. So from an efficiency perspective, there's a benefit to having that. But I wanted to point that out more so for, it's important to understand that you want to have some kind of structure. What you don't want to fall into is the trap of you decide to find one person X dollars and another person a different amount, because that what you don't want is then to say all of a sudden you're singling this person out, maybe because it's the neighbor of a committee member that they don't get along.
Right.
So I wanted to bring that up because it's important that whatever enforcement procedures you're following, that you're following something and that you're consistent with everyone throughout the community.
Yeah. And at the end of the day, let's all try to kind of remember the goal of this whole thing is compliance with the documents, right?
Correct.
So the goal of finding, just like the goal of sending the letters, is to try to gain compliance. It's not to, although sometimes it's a nice extra benefit, it's not to have an extra income stream for the association. It does us no good to levy a $1,000 fine, get paid, and still have the underlying violation. So if the goal is compliance, then my approach is I like to use the fines as sort of a bargaining chip with the owner to try to gain the compliance. So if I see the committee's approved the $100 fine up to $1,000, and let's say I wind up in mediation, or let's say there's multiple violations and we have $3,000 or $4,000 worth of fines on the table, and I get into mediation for an HOA with the owner, and I say, look, maybe I use that as a bargaining chip and say, hey, I can get the board to back off of the fine if you can clean your roof by such and such a day, or if you can get that vehicle off the property within 30 days, and maybe we'll cut that fine down from 4,000 to 1,000 or something like that, and use it as a tool to try to gain compliance. That to me is where it's more important than just getting it collected.
Correct. And I would agree with you there 100%. My 14 years have shown me just that. Many times people just get annoyed by having to show up to the hearing. And again, I mean, no matter what size your community, if things get around in Palm Beach and Broward, and it's such a small world, imagine in a community, word is going to get out. And if you're consistent as a board, word will get out and the residents will start to making sure that their properties are the way they need to be based on the covenants of the association. I have a question here from Carolina. She says, should an attorney request an opinion? Sorry, should an association request an attorney's opinion? Does that become part of the official records of the association?
That's sort of a yes and no answer.
I knew that was coming.
Technically, yes, it is part of the association's official records, but the statute says that it is not open to inspection by the membership because it's attorney-client privilege. So there are exceptions in the official record statute. There are certain things that you cannot show an owner upon request, and one of those is the communications between attorney and client. So if we give you a formal opinion letter on an issue, that is not discoverable by the general membership. Now, if we send a violation letter to an owner, well, that's not a communication between us and the client. That's a violation letter to a non-client. That then becomes part of, whether it's that part of that owner's file or just part of the official records, that can be inspected by the members upon request, but not our internal communications where we're giving you advice.
Correct. And as a tip as well to those managers and board members in attendance, I know we've had, when you start getting aggressive with your violation process, I know we've had records requests from residents that have received the violation. I want to see all the violations that have been sent to the rest of the residents to see if you're doing any selective enforcement, because that'll be a pretty easy case for anyone to take on. So again, it's important, if you're sending violations for roof, make sure that you're going through, you're doing a thorough job, that everyone that has that same issue is receiving a violation, because you don't want to be put into a position where all of a sudden you receive a letter that you're doing selective enforcement, and you're finding yourself, having to hire an attorney to represent you in those cases. I have here a question from an anonymous person that says, a chairperson of a compliance/fining committee is elected and approved at a meeting. In order to remove that chairperson, must they also be voted on a meeting?
Yeah, I mean, I would say so, unless the documents delegate the committee makeup to the president or some other director or officer. But ultimately, these decisions are board decisions, and committees serve at the pleasure of the board. So that implies the right of the board sitting at it as a duly called board meeting to make those decisions. But I've seen plenty of bylaws that will say, and it'll be used under officers and under the president's authorities, it might say the president shall have the authority to appoint committees or to appoint committee chairs. Well, if that's the case, then I would say that that's a delegation of that authority directly to the president. So it may depend on your documents, but in general, I think that it should be done at a board meeting. That's just as a practical matter, just for best practices.
Excellent. I have another one here from an anonymous that says, we have brought in the sheriff to enforce speeding. We fine on second offense. Can the HOA allow the sheriff to fine as if on a public road?
My understanding is that, yes, if you have a public road and you have a sheriff that's willing to do so, that you can bring that sheriff into the property. Usually they'll just conduct sweeps, maybe random sweeps of the community. Correct. But they will issue tickets. That's not necessarily fines. It's their actual tickets, as if it's on a public road, as if they caught you speeding on the turnpike or wherever. But my understanding is you need to engage them through some sort of contract. We'll need to get into a formal contract with them for their services. And I think most agencies, I know Palm Beach County Sheriff's, I believe, does require that a traffic study be performed and provided to them before they engage in that. So it's a process, but ultimately, yes, the answer is yes, you can engage them if they're willing to do it and if your roads are public roads.
Correct. And there's even some companies, for those that aren't public roads, that are focusing on, some security companies are focusing on putting up those speed trap, the ones that will show you the miles an hour, have someone there. It's a bit of a process. We have found it to be challenging, but at least you have records to be able to send a violation to that individual. And then you have, record of someone measuring that speed and then putting them through that process. I do have a question here. It's not here, but let's say if a resident does receive a fine, does the association have the ability to eliminate their voting rights if they're delinquent on that amount?
Excellent question. Many, many years ago, the statute said that you could suspend voting rights and even use rights in the common properties for non-payment of assessments. So we would always take the position, well, a fine is not necessarily an assessment, so you can't do that. But it was maybe, and I can't remember if it was 6, 7, 8 years ago. It's probably been a while now. They actually changed that language, and now it says that if there's a delinquency in the payment of any assessment or other monetary obligation owed to the association for more than 90 days, that you can suspend not only voting rights, but you can suspend use rights in the common areas or recreational facilities for as long as that amount is delinquent. So yes, if there's a fine outstanding and it's been more than 90 days, that's the key, is it's a 90-day threshold. Then once they hit that 90 days, you can then suspend those rights. That suspension must occur, though, at a duly called board meeting, open board meeting. So that suspension does not go to the committee on 14 days notice. A fine or a suspension for violations goes to that committee and has to be approved on the 14-day notice. But the suspensions for delinquencies is a board decision, but must be at a board meeting and only once they get 90 days delinquent.
That's correct. And I have found boards, there's different tricks that are used as well. We have one HOA that they'll even suspend the access to the community. Now, don't freak out. They allow guests, so they have to come in. They're still allowing them to come in, but they have to call in. So it makes it very challenging. It's created a challenge for the community in itself, because now you have a longer line to get in. They have to come in as a guest. Yeah. But either way, there's different tricks and different ways that board members and associations manage those situations.
And it's funny you bring that up, because I always include this in my board certifications, because this is another one of those areas that's changed. The language in the statutes changed over the years. I've always been of the opinion that you can suspend transponder access to and force owners to go through the visitors gate if they've gone 90 days delinquent. I think that's part of the suspension of use rights that you can do, but it's not 100% clear. The statute says you can suspend common area use rights. That that's clearly the gym, the clubhouse, the pool, that sort of stuff. Is going through the gate really considered common area use? Is that really a proper suspension? And that could be argued either way, but I've always taken the position that it has. But the interesting thing is, there was always a question as to whether or not you could do that anyway, because the statutes used to say that any suspension could not impair a person's right of ingress and egress to the community. And that word impair is very, very broad. I mean, and I could certainly see the argument that forcing somebody to go from the automatic gate with their transponder into the visitors line was impairing their access rights. So we used to always have to argue, well, it's not really an impairment. They still have the ability to get in. We're not impairing their right. We're not taking anything away. They just have the slight inconvenience of having to go through the visitors gate. Well, now they've changed that statute, and instead of saying impair, now it says that a suspension shall not prohibit the ingress and egress to the property. So now to me, it's very clear, and I can make the argument that, hey, we're clearly not prohibiting it. We're just impairing it now. So I think it works out perfectly fine. So yes, I'm always of the opinion that you could do that.
Yeah, and this goes to show, and that's why I brought this question up. It really goes to show the importance of reaching out to your partners, and the attorneys are part of that partnership. There's so many changes in the law, and while we do our best, I know at Affinity we do our best to try to keep up with everything that's going on. There's some major legislation that's about to get approved right now that are going to change for next year. It's important as a board and your manager that you just pick up the phone and just get that quick opinion. I mean, it's going to take 30 minutes, an hour, but at least you have that in your records to say, look, this was the opinion of our attorney, and this is the direction that we decided to take. It helps you also from a leadership perspective, because as a manager, it's easier to reference, hey, we have this professional opinion, or as a board from our attorney that's advising us that we can do this. So again, I can't stress enough the importance of reaching out to your attorney or to your partners, I should say, and requesting that information prior to making any of these big decisions that will impact your residents. I have a question here, Stephen, from an anonymous again. Can a resident accuse/sue the board for selective enforcement, or is that only available to a board?
And I think that's a perfect question that can kind of dovetail into the discussion over what we do when we haven't been enforcing our documents properly, which I think is coming up in the outline that we've been working off of. But the answer to that question is you can't sue for selective enforcement. That's not a cause of action. You can't say the board has been selectively enforcing the document, so I'm going to sue the board for selective enforcement. What selective enforcement is it's a defense to a lawsuit. So you can't sue a board for selective enforcement, but if a board is attempting to enforce its documents to you on an issue, and you find that there's 5 or 6 other things out there that aren't being enforced, you can raise selective enforcement as a defense to the action against you. So it's really a defense, not something that you can use on the offensive.
Okay, excellent. And Robert here asked us some slightly similar question. I think it has to do more from a from a homeowner perspective. How can a board correct a selective enforcement complaint? Our rules indicate glass insert in front of the door cannot exceed 10 by 10. However, no window meets the requirement. I have been declined because my glass door, I guess, does not meet the rules.
Well, it seems like there's a couple of issues in that question. I mean, for the first question is the board trying to enforce a rule that can't be enforced because what they're trying to impose doesn't exist? I mean, that's a kind of an independent issue, and in which case now we're talking about a rule and whether or not that rule is reasonable. We judge rules on a reasonableness test. So I would argue that if you have a rule that can't be complied with on its very face, that's probably an unenforceable, unreasonable rule. But I think the bigger question is, what can a board do if there has been selective enforcement in the past? And how do we correct that on a moving forward basis? And there is a process. I call it cleaning the slate, and I've used it multiple times. Basically, there was a case from many years ago that says that if a board has been lax as to a particular violation over time and has allowed certain things, but we want to, on a moving forward basis, start enforcing that provision again, you can do that. What you have to do is you have to be willing to grandfather the existing violations, of course, because they've been in existence and nobody addressed them in the past. But you can republish what's called republish the restriction or clean the slate by sending a letter out to the community saying, hey, as of this date forward, we know things have been a little lax in the past. We know we haven't been as on top of things as, past boards maybe haven't been as on top of stuff as we would like to be. but on a moving forward basis, this is the rule. It's been in existence since whenever. We even published the rule in that communication. This is what it says. And as of this date forward, previously existing violations will be grandfathered, but on a moving forward basis, we will be vigorously enforcing the restriction. And by putting the community on notice of that on a moving forward basis, you can then start to enforce that provision in the future. So that's one issue with regard to selective enforcement in terms of curing it. The other thing I like to mention on selective enforcement is always remember that selective enforcement is an apples to apples or oranges to oranges comparison. If the board has not been enforcing its vehicle violations consistently, that doesn't mean they can't enforce the pet restrictions or some other restriction in the documents. We only look to the selective enforcement of the particular violation. The fact that you haven't been enforcing one thing does not mean you've lost your ability to enforce your whole set of documents. So we look at it as a violation by violation specific issue.
Excellent. And I would agree on that 100%. Kathleen has a question here. Does the appointment of members of the compliance or fine committee have to be done at a board meeting?
I think, again, it gets back to whether or not there's a delegation in the bylaws or somewhere else to giving that authority to a president. But for the fining committee, being a little conservative on that because it's governed by statute and because the statute says the association shall appoint that committee, I would do that at a board meeting. The other thing you could possibly do, and this kind of applies to a lot of board decisions, although I wouldn't do this for extremely important decisions, and I would always ratify it at your first available opportunity. But there is something in 617, which is the Not-for-Profit Act, which governs over all not-for-profit corporations, including condos and HOAs, that says that you can act by unanimous written consent of the board. So if you have an issue that needs to be addressed and you don't have the time to call a board meeting, or you just want to, or maybe it's a minor, simple issue that you don't feel merits the need for a board meeting, but you know that every single member of your board is on the same page, you can have that resolution set out in writing in a document and have every single board member sign and date it. And by unanimous written consent, that will act in place of a meeting. I would still caution you, though, just as an extra conservative layer of protection, at your next subsequent or available board meeting, ratify that decision. I like to use that process really for emergencies or things that need to be done fairly quickly, where you can't really get everybody together at a board meeting. But the statute doesn't really say that. So arguably, unless there's something that is required to be done at a board meeting, like a special assessment or certain types of rules, things like that, or your budget, I think making certain decisions, appointing committees. I've done unanimous written consents where somebody wanted to appoint a committee, and I put the resolution appointing the committee and naming the names of the committee in the resolution, and have all 5 board members sign off on it. And to me, that affects the process.
Correct. And to add to what Stephen said, I mean, obviously we're still in the midst of COVID. That's a factor of its own. But that shouldn't hold you back from doing the work that you need to do. The managers, I'm very grateful for the team members that we have, and also for all the individuals in our industry, managers, janitorial individuals that work in the management field, because really our sector has not stopped working since COVID hit. And it hasn't stopped us from doing what we need to do. Was there a pause with certain violations? Yes, because we understood that people were at home and so forth. But as Stephen and I were talking about earlier before we got on the webinar, we have seen many communities that are now fixing their homes. You see it even with homeowners themselves. Because they're home, they can kind of do their own GC work. So you're seeing people doing what they need to do, but it shouldn't stop you from holding your committee meetings, because as long as you're posting your notice and you're, let's say, doing them over Zoom, whatever way you're hosting them, and have someone, maybe one person at the meeting, you can still host it that way. And we're seeing that's still occurring in the midst of COVID. And also, I wanted to mention, when it comes to violations, so certain documents aren't as clear. We've gotten the question about the door and the specific frame with the glass and the size. That goes to show that there's a specific architectural guidelines, it's what they're called, that outlines what are the guidelines for certain repairs that the owners may make or changes that they may need to make within association. If your association has that, I applaud you, because that makes the job much easier for everyone, for both the committee as well as management. If you don't, I strongly urge you to work with your committee members, with management, to be able to build that, and then ultimately make sure you have that reviewed by your attorney to make sure that everything is kosher. What those guidelines are, they provide to the resident to let them know, okay, these are the kind of doors that are permitted. Some associations go to the specific of what kind of brand is permitted, what size windows, what color the windows, what kind of frame does the window need to have. Same thing goes with the roofs. So it makes it much easier to manage your covenants and conditions when you have these specific guidelines. So if you don't have any, I strongly urge you to start putting them together. And you'll find that you're going to have the consistency within your community, probably much closer to when it was built than in some communities that don't have guidelines, and you'll see French windows in one and you'll see solid pane glass in another. So it's very important that if you don't have these guidelines, that you work with your committee to put them together.
And that's extremely important, especially in an HOA context, because 720 now specifically says that if you want to deny somebody's architectural application, that denial now has to be based upon either something in your declaration, in your governing documents, or based on guidelines and criteria that are adopted pursuant to authority contained in your declaration. So if you're trying to turn somebody's chain link fence down because you don't like chain link fences, do you have a guideline in place that says fences shall only be wooden fences or white bronze fences or whatever it is? It's very important that, especially HOAs, because it's specifically in 720, have these types of guidelines in place, because you're going to open up a door to possible challenge if somebody tries to do something and there's nothing in your documents regulating the types of materials or colors that they can use for their improvement. Now, that being said, two things always come up is, you may have a community where just by the common scheme of the community, everything is a certain way. So I know there are a lot of HOAs out there, especially attached townhomes or that type of thing, where everything is painted white or off-white. Every roof is a red barrel tiled roof, and somebody wants to put on a completely different type of roof or paint it, brown or something like that. I would argue that, you have an implied architectural guideline by the common scheme of your community, because no building, everything is that same color or has that same type of roof tile or whatever it is. But again, I would still go out of your way if you can to create those guidelines, because it'll only help to protect you. And then the other limitation is you can't always think about everything. So, try your best to hit fences, roofs, things, types of plantings, landscapings, things like that. As a funny example, we had maybe 10 years ago or so, we had a community where an owner wanted to put a gravestone in their front yard. They wanted to put a little grave type thing because the person's husband had passed away, and I guess he tended to the garden all the time, and they wanted to put a little grave kind of signifying that in their garden. And the association didn't like that and didn't want to do it. And so, of course, the person said, well, where in the guidelines does it say I can't do that? And my response was, well, what association in the world would ever even think to have a guideline on gravestones? So, there's certain limitations. We can't always think about every little thing, but to the extent that you can control it and think about it and get some guidelines in place, you certainly are encouraged to do that.
Correct. So, Stephen, I want to be respectful of everyone's time. I know we do our best to keep these at 1 hour. Is there anything that you want to close off with? Maybe any last tip or any info that you want to provide the board members and managers that are on the call?
I think, again, the key of covenant enforcement is a few key points that we've kind of talked about. Number one is the goal is compliance. Use the finding process, use all these processes together to try to gain compliance, but it's not about harassing the owners. It's not about trying to gain an extra income stream. There are going to be difficult owners. There are going to be those resident dissidents out there that are just going to dig in. Sometimes they just want to be heard and dealt with professionally. Don't take it personally. Exercise your business judgment. Exercise your judgment in accordance with the documents. But again, the goal for this whole thing is to have a better community, to comply with the guidelines, to increase property values, and to make life better for the residents and the community as a whole. So, and again, be guided by the business judgment rule. That really kind of overarches all of your decisions, whether it's covenant enforcement or maintenance issues or whatever it is rely on your experts, rely on your accountants, on your management professionals, on your attorneys, on your engineers to make your decisions, and don't be hesitant. Don't hesitate to make those calls and get those people involved. It's always better to get the right answer first and then argue about the bill later. That's always been my approach into billing is call me, let's have a discussion, let me give you the right advice. And then when you get the bill later, if you have a question, we can always figure it out later. Don't hesitate because you're afraid of it and then wind up in a much, much worse problem later on.
Correct. And it'll be much more expensive. So thank you, Stephen, for that. We've had several people asking if we're going to post this webinar anywhere. We will. I'm going to share right now while I give my closing statement a screen. So if all of you can pull out your cell phone, we will be posting the webinar on our YouTube page. If you scan this code, it'll take you straight to our YouTube page. I've also provided the contact information for Sachs and Sachs and for Affinity here. As Stephen said in my closing statement, I just want to say that as board members and managers, more board members, but you have a fiduciary duty to follow those documents. So it's important that you go over them, understand what are the rules and regulations and the covenants that you must abide by, and that the residents should be abiding by as well. and making sure that you're guiding yourselves by that. Further, as Stephen said, I want to stress that it's important that you work with your partners. It's important that you contact your attorney, you work closely with management, and that way you understand what direction you want to take. Lastly, I wanted to wrap up by really thanking Stephen for being here today. It's been a pleasure doing this webinar with you. The information that you provided today, I'm sure our listeners today were able to gain the value. I also wanted to thank my team that worked behind the scenes to put the webinar together. Thank all the board members that are here today and also all the managers. We look forward to doing this webinar with Stephen again or another webinar, and we hope to see you all again. Thank you
Appreciate the
and have a
opportunity.
great
Yeah.
day. No
Thanks a
problem. My
lot.
pleasure.
Take
Bye-bye.
care.